Hello, I'm Brian Hudson, founder of the Equal Parenting Alliance and also one of the many parents who has been through this broken system a number of times now. But I won't talk about my circumstances. This is about helping you to help yourself with your own case. Before I start, I'd like to just make a little disclaimer so that you can't sue me. The guidance I am giving you in this video is just guidance. I am not qualified to give you advice, and you accept that any decisions you make are a result of considering this in the light of your own circumstances. And you should also get your own legal advice, even though you very probably can't afford it. Everything I share with you in this video is the result of my own extensive research, advice I've received from professionals in my own case, common sense, my innate sense of child centricity and justice, seeing firsthand what my own children have been through, being on the receiving end of some quite appalling behaviour, reading case history of many cases around the world, making some bad choices of my own and having to clean up the mess. I'm not a solicitor or a psychiatrist or a social worker, so my voice is definitely not the be-all and end-all. But I hope you will take some useful insights from it and you will be better able to navigate your own journey as a result. So the focus of this video is dealing with the spectre of the malicious non-molestation order, which is a frequently used, or rather I should say frequently abused perhaps, as a tactical play in family court proceedings, mostly when it comes to child arrangements. The intended purpose of these type of court orders was to provide a shield to protect those who are on the receiving end of genuine abuse or genuine threatening behaviour, and therefore at real risk if the court does not put restrictions in place. However, far more common is that they are applied for in cases where there is no such behaviour that warrants the application. Therefore, they are clearly nowadays being used for two main reasons. Possibly, or rather probably, both of these reasons in tandem with one another. And the reasons are: one, to prevent the other party's contact with the children; two, to access legal aid so that the applicant of the non-molestation order can have their legal fees paid for by the state. And that is the case whether or not their claims are later proven to be without merit. The latter of these two is borne out simply enough through statistical analysis, which shows a huge increase in applications for non-molestation orders when legal aid was withdrawn, which is obviously no coincidence. Sadly, not only are there no consequences to this type of strategy, but it assists the person who gains the non-molestation order in a strategy of parental alienation, because it justifies there being no contact with the children, which in turn means that it is far more likely that a child arrangements order will ultimately be made in their favour, not least because the court and social services will be much more likely to consider that it would be too disruptive to the children's routine to materially change the contact arrangements after the long haul in terms of the time investment required to overturn these type of orders and the swaying of opinion that accompanies them. So when an application for a non-molestation order is submitted to the court, it can be done on a with or a without notice basis. The majority of the time, the applicant will request that they are given an order without you even being notified that an application has been made, and therefore you are given no opportunity to contest it. The order will just be made, and you will be notified of what restrictions the court has placed upon you, and that if you breach those restrictions, you will be arrested and face being sent to prison. Now, theoretically, at least, for an order of this nature to be made against you without you having the opportunity to contest it, evidence must have been presented to the court which proves to them that you present a risk, and therefore the order must be made urgently and without your knowledge. If you have not done anything to warrant such an order, there can't have been any evidence submitted to the court sufficient to give this end result, unless that evidence has been falsified or tampered with, and a very good job has been done in terms of creating convincing evidence. So if a without notice application is made, the chances are that the reviewing judge will insist that they will only hear the application on a with notice basis. And so when that is the case, the applicant will be directed to send a copy of their application, statement and accompanying evidence to you at least 2 weeks ahead of the hearing date. There is every chance you won't receive it until just a few days before, but don't panic. Not much will happen at the first hearing in any event. Right, what happens now? Well, you will probably be pretty scared to begin with, and there will be allegations made in the application which are pretty upsetting. So first thing, take a deep breath, review the statement and evidence and make some notes. At this point, you are not required to submit a statement rebuffing each of the claims made against you. Sadly, you are actually now entering a long and drawn out process which could take anything from 4 to 6 months to conclude. At the first hearing, the judge will simply want to know whether or not you are contesting the application. If you are not, the judge will grant a non-molestation order to the applicant there and then. So obviously only do this if A, their allegations are true, and B, they are relevant in terms of those allegations actually mean you are the risk of harm that it is alleged that you are as a result, and therefore a court order is appropriate and necessary. Assuming the allegations do not have any merit, you should make it clear that you are contesting the application. This means that the judge will need to set a timetable to deal with the application so that there is sufficient information before them from which they can make an informed decision about whether it is appropriate for them to grant the non-molestation order. The applicant will have had to submit a draft order, so you will be very clear about what restrictions they are seeking the court to impose upon you. If the allegations made are false, twisted versions of the truth, irrelevant, or a mix of all of those things, then you simply must contest the application. I've heard of a number of cases where solicitors have advised their clients to accept the application even though the allegations don't have any merit, and therefore an order is made against them. Do not agree to this. It can only harm your chances of contact with your children, and it will give you a mountain to climb later. Your lawyer should never be recommending that you accept an order of this type unless the allegations made against you are true and are relevant, and therefore such an order is justified. If your lawyer recommends that you do not contest the application when the allegations are false, then you need to find yourself a new lawyer or a new Mackenzie friend, or perhaps just represent yourself. So, in this hearing, depending on what has been submitted in the statement and evidence by the applicant, you need to have considered what evidence the judge will need to have presented to them as the timetable for this process is set. In all likelihood, there are children involved, so if that's the case and parental alienation is a factor, ask the judge to order that the school disclose each of your children's child protection folders, assuming your children are at school, as this may have useful information inside. Also ask the judge for a full police disclosure so that you are able to see what, if any, complaints have been made to the police about you. This is really, really important, because when people are lying to the police, they make mistakes, and these will be recorded by the police, and you will then have a much easier task of unpicking those lies by being able to reference text and email communications, diary entries and such like. If the child protection folder is disclosed by the school to both sides and the court, the judge will want each of you to write a statement about the contents of the folder, and you will also be able to include in that statement any matters which are relevant to the police disclosure if that is also ordered. If there are multiple allegations made against you, the judge will ask for a Scott schedule to be completed by the applicant, which must then be sent to you to reply to the allegations in that Scott schedule, limiting the number of allegations to only the top 5 which have been raised. The assumption behind this is that if the top 5 are found to be true, then the rest probably were also, and if they are found to be false, then the rest probably were false as well. The Scott schedule is a single document which is presented as a table, just like this. On the left, the applicant will have the date in the first column, the details of the allegations in the second column. The third column will be for reference documents related to each of those allegations. The fourth column will be your response to each of those allegations. The fifth column is for referencing any evidence to support your response. And the sixth and final column is for the judge to make their comments and their judgment. The judge will order a date by which the applicant must serve the Scott schedule on you. You will then have 2 to 3 weeks to draw up your response, and then you will serve that document on the applicant and file it with the court. There will then be a dispute resolution appointment a few weeks later to see if agreement can be reached between the parties without the need for a final hearing. The final hearing will have already been timetabled for 4 or 5 weeks after the dispute resolution hearing and usually lasts 1 day. If agreement isn't reached or the application isn't either withdrawn by the applicant or accepted by you, then you will be required to attend the final hearing where the judge will review your statements and evidence. There will be an opportunity for you to cross-examine one another, and the judge will then make their judgment. So all in all, it's not as daunting as you might imagine, but you need to understand what is behind the application being made in terms of strategic play by the other side. If the allegations that have been made are not true, you must contest the order, because if you don't, it will materially impact your ability to achieve success in your child custody case. And that probably means less access, or maybe even no access to your children. I hope this video has given you some useful insights. I'll be posting more on different but relevant topics on a weekly basis. Ultimately, the law needs to change so that these crimes against children and parents can no longer happen. Your strength is needed to be part of that fight, so please click the link below to visit the Equal Parenting Alliance Facebook page. Complete the survey. There's a link in the comments below. Like and share and follow the Facebook page, and do whatever you can to help us achieve the change in the law. The action plan for how we will get the law changed together will be announced on Father's Day, Sunday the 16th of June this year 2019 at noon as a Facebook live broadcast. Follow the page so that we can keep you informed of developments. Remember, stay calm, stay focused, keep to the truth. There will be setbacks, but you only fail when you give up. Do not give up. You've got this.